Jeremy, question for you. You and I have talked a lot about the importance of litigation as part of movement building, not just what the case is, whether they win or lose, but building the overall movement. Talk about that.
One of the biggest challenges I saw actually when I first came to Open Primaries 10 years ago, and seeing work being done on ballot initiatives and work being just starting to be even conceived of being done in legislatures, and there was nobody going to court. And if you look at every successful change movement in American history, litigation has been a key component. And if you look at any major law that has been passed in this country over the years that has granted rights to any category of voter, oftentimes it has its beginnings in a case. That's why I think, we've been spending a lot of time in the last year really bringing attorneys together, developing ideas, working to support each other, because this litigation, I truly believe, is going to be the future of the primary reform movement.
Joining us now to explain this lawsuit, the attorney representing the plaintiffs and former Lieutenant Governor Boyd Rutherford.
By having these closed partisan primaries, you're excluding these 957,000 voters. Under our state constitution, it basically sets out what the requirements are to be able to vote. And in that, you shall have a right to vote in all elections.
We see this case, these issues, as raising a substantial constitutional concern. You have 1 million plus Pennsylvania voters who are unable to translate their vote into effective representation.
If you want to vote in this election, why don't you just join a party? What's the big problem with that?
I think these issues are starting to bubble to the surface, and what we tried to do is go to the core of what the real critical issue is. Can you condition our participation in the democratic process on joining a private organization?
Ever since women's suffrage through the civil rights arena, there have always been arguments claiming that there's a problem, there's a concern, there's an issue with a particular group having the right to vote. Those folks have always been on the wrong side of history, because there is no reason why an American citizen shouldn't be able to vote in a public election.
Well, it's not about the parties. The parties can select their leadership however they want to, but the state should not pay for something that is blatantly unconstitutional.
Welcome, everybody. We're here today to talk about ways the open primaries movement is taking our case into court. And I'm really excited to introduce all of you to Boyd Rutherford, former Maryland Lieutenant Governor and partner at Davis Agnell, Rappaport, and Skolny; Matt Fontana, a partner at Fager Drinker in Pennsylvania; Chad Peace, the legal advisor to the Independent Voter Project; my close colleague Jeremy Gruber, the senior vice president at Open Primaries; and Michael Palelli, who is a retired University of Illinois at Chicago law professor, and the only one who wasn't in that video, but that will change tomorrow. I would encourage all of you to tune in and watch him on CNN tomorrow morning. So welcome all of you. We're here to talk about really 3 specific open primaries lawsuits: 2 state cases in Maryland and Pennsylvania, and a federal case in Florida. But I want to be very clear, these are not the only legal efforts underway. There's important lawsuits right now in progress in Wyoming and Oregon. There's an emerging defensive effort in Texas. But I wanted to bring this grouping together because they're at the heart of some very important and cutting edge legal actions and legal questions. So let's dive in, and then we'll open it up for your questions. I want to start, Boyd, with you and with Matt. Both of you are in state court in Maryland and in Pennsylvania. Take 1 minute and orient people to the cases that you've brought and their current status. And let's start with you, Matt, and then we'll go to you, Boyd.
Sure. And I want to thank you again for having us. This is a really great opportunity. Pennsylvania's Constitution has a free and equal election clause that basically stands for the proposition that one voter can't have more power than another voter. Our argument is by excluding independent voters from the primary process, you are giving major party voters who have access to that primary process power over the election and an ability to translate their vote into representation that is not equal to the power granted to independent voters who can only participate in the general election. And in many times, those general elections are non-competitive, and therefore they really don't have any chance to translate their vote meaningfully into representation. And that's really what our case is about.
Got it.
Well, thanks again for having me on. Similar to what is happening in Pennsylvania, we also have a fair election clause in Maryland. It's under what's called our Declaration of Rights, which essentially says that the best form of guaranteeing liberty is through free and fair elections, and therefore all citizens should have the right of suffrage. That is further supported by our state constitution, which states that all those who are duly qualified to vote shall have a right to vote at all elections. It does not make a distinction between primary and general elections. And just like Matt said, in many of our jurisdictions, the primaries are outcome determinative, where all the action is in the primary.
Right.
Not able to select in the primary, by the time you get to the general election, it's a foregone conclusion. And so we're bringing an action and saying that while the parties can still choose who they want to participate in their primaries, we're saying the state can't pay for it because it does violate the Constitution and the constitutional rights of Maryland citizens who we classify as unaffiliated because they're not affiliated with any party.
I want to put a pin in that thing you're saying, Boyd, about the parties can do what they want, but the state shouldn't pay for it if it doesn't meet certain constitutional standards. But I want to come back to that. But let me first go to Michael. Michael, you've been working on a federal case in Florida for the last 4.5 years. That was a hair's breadth away from the Supreme Court. Tell us about that case. And Chad and Jeremy, please chime in about the role that open primaries and IVP played in supporting this final push to the Supreme Court.
Yes. Yeah, thank you. I started this lawsuit because I realized there was no recourse under the Florida Constitution, unlike other states. And it also appealed to me to file in federal court because if I prevail there, and especially if it got to the Supreme Court, we wouldn't have to do piecemeal litigation state by state, especially if it went to the Supreme Court. For once and for all, we'd get a clear answer, and the court would no longer be avoiding the issue. So I filed this lawsuit basically on the First Amendment, that the First Amendment very simply says you have a right to associate or not associate with political groups, a right to speak or not speak on their behalf. Now, what Florida does, and it surprised me because it wasn't that way in Illinois, when I came to the state and registered, my political preferences are a public record. You have to state whether you belong to a party or not, NPA. Right. And that's a public record. And once you do that, you read the form, it says, I affirm that all the statements are true under pain of a third-class felony. So, it's kind of bothered me because that wasn't the rule in Illinois. I could just come and pick up a ballot, any party. But I thought, okay, no big issue. I don't like it. But then I found out that my real estate taxes were going to pay for primary elections in which I could not vote. And specifically, the county commission, which sets my taxes, was one of the organizations, political groups, whose primary I could not vote in. So it struck me as, that's really what we call taxation without representation.
Right.
And so I filed the lawsuit based on a violation of equal protection, that a voter should not be forced to give up a constitutional right in order to have an effective vote. This reminds me very briefly of what happened in Illinois, where patronage was king. And as soon as a new administration got in office, they'd fire everybody of the opposing party. I'm quite familiar with that. And a colleague that I know filed a lawsuit, and I'm familiar with that lawsuit, that went all the way to the Supreme Court, where the court said you cannot condition the right to a public benefit on a political criterion.
Right.
And it just seems to me this is exactly the
there's
same.
similarities.
I should not be forced to espouse the preference of the state at the price, or otherwise lose my right to vote. The state of Florida, like other states with close primaries, is putting an unconstitutional condition on my right to vote. It's kind of take it or leave it. If you want to be effective, you forget your principles and you vote, which is not really what you believe, and you at the same time inflate the membership of both parties, which is false. Okay.
I want to go back.
John, can I make a quick point about?
Oh yeah, sure, Jeremy.
About some of these cases. Quick point about Michael's case and what's so important, because it achieves several firsts that are going to help us build in the area of litigation. First and foremost, he won. He won on standing, and that sometimes gets lost because the case was eventually denied cert. He won on standing, which means that going forward, we now have an 11th Circuit decision that says an independent voter has the right to bring these types of cases before the public. That's a really important step forward. But he went so much further than that, but also in the 11th Circuit decision, it went into an extensive discussion about the growth of independent voters, the rights of independent voters, and the need to start thinking about potentially reversing some of the case law, the older case law that has handcuffed the courts in this arena. No court has ever, that I've ever read their decision, has come to that level of detail. And that was another really important step forward. And then finally, the fact that the Supreme Court went to conference on this case means that at least one justice and one clerk thought this case was already ready to be heard. It means that for the very first time, Michael got the Supreme Court to start talking privately about the growth of independent voters. And that's going to also be a really important step forward. And then finally, just a quick note about both Boyd and Matt's cases in Pennsylvania and Maryland. There are so many opportunities right now that have not been explored yet in terms of state law actions. A lot of the attention on this issue in the past has focused on the federal courts and will necessarily continue. But there's so many opportunities to look at different ways of exploring state constitutional provisions and seeing where there are opportunities to make progress. And I think Boyd and Matt are really leading some important cases to explore those things.
Thanks, Jeremy. That standing issue is so important, because I know many cases in the past have been dismissed without even getting to the merits of the case. They just say you don't even have a right to sue. So that's a big step forward. Chad, I want to ask you a question. So you, 11 years ago, back in 2014, it both seems like 4 hours ago and a lifetime ago, you and Harry Kresge brought a really landmark federal case fighting for the rights of independent voters. It didn't win. It was pushed aside. But how have things changed in those 11 years? What are you seeing, good, bad, and ugly, that's new? Oh, you're on mute. You're on mute, Chad.
John, we got a couple hundred people on Friday talking about the voting rights of independent voters. That's what's changed. I'm pleasantly surprised that this many of you are willing to join us on a Friday to talk about this kind of issue. 11 years ago, it was a few of us in a corner, and we may have all been in our own corners, but the fact we've finally started to find each other and get together on a call on a Friday afternoon is, I think, the biggest thing, which excites me. Why did we pick New Jersey? Because that was a state where literally 50% of the voters are registered independents, can't vote in the primary. They have a 5% turnout, right? And we always knew this was an issue setting case. I do define, our legal strategy. It could easily be defined as losing, but in that case, we got our first argument from the Third Circuit. We got to argue in front of the Third Circuit you know, some people, I don't know this history, and I don't want to make the comparisons of, you know, some of the greats in history, but there was actually a documentary recently with Thurgood Marshall, right? And I think if you come on a call like this on Friday, you probably know the Marshall Court, right? Well, Thurgood Marshall himself was asked in a documentary, he said, "What was your most important case?" He says, "The case I argued in Smith v. Allwright."
Right.
Right? That's the white primaries case in Texas where the Democratic Party didn't want Black Americans to vote. That was Marshall himself. So that was the most important case he argued. Okay. What else he said that I didn't know literally until I actually watched that because somebody told me I had to watch it the other week was the judge in that case who had actually participated in writing the law contacted him after and said, "Have you filed writ for certiorari yet?" And he says, "No, but I'm going to." And he goes, "You ought to, because you're going to win." Right.
Wow.
I mean, that's just something to put into perspective is those cases. And then when he goes on to talk about it, he talks about how many, there was 4, 5, 6, 7 cases that they thought were going to go here and there. And like, these aren't things that happen overnight. The fact that Michael took this Florida case all the way to the Supreme Court and he got a victory in that he put it on their discussion table, right? You know, whether it's the case we have in New Jersey where you get a court. So just so you understand where that case landed, the Third Circuit ruled a single judge. The other 2 judges didn't even put their names on it. So history will never look back that there was who the other 2 judges were. The holding is literally just join a party, right? So if you're looking at through it, that was the issue setting case. You know, maybe we're just defending our loss, but but I think it was actually very good. We wanted to set the issue. We wanted them to say, "Okay, Supreme Court, can you say just join a party to a voter who wants to vote at an integral stage of the election?" So,
right, particularly with what Michael's saying, that the voter registration form says it's a third-class felony to say something that you don't believe in. So it's kind of.
So when we saw Michael's case, you know, we had an opportunity to file an amicus and looking at the quality of the litigation of putting, you know, one of the things people don't think about in the lawsuit is, yeah, you can go file a case, but it's important to keep it on issue and have it and bring it, you know, and that he had brought it all the way by himself to the court, doing such a great job. I think it's the combination of that case, the case we filed, the case Boyd's working on, the case, that, you know, everybody else is in, is what will ultimately get the Supreme Court to go, okay, now we're ready to do this.
Yep.
So, and who knows when that will be.
Thanks, Chad. Boyd and Matt, so answer the following question. What if you win? What relief are you seeking? What are you asking a judge to do? Because judges don't write policy. Judges just rule something's unconstitutional. So what would be a successful outcome in Maryland and Pennsylvania?
I'm happy to start there. So our relief is very specific and you know, we think pretty direct, that the closed primary portion of the Pennsylvania election code is unconstitutional as to those voters who have declined to register for a party. That's what we're asking for. And then what happens after that is a decision of the state legislature, is a decision of the Secretary of State in terms of the election administration. But our relief is very direct and very specific in looking for that declaration that this particular provision violates the Free and Equal Election Clause and therefore can no longer be enforced.
Got it.
Very similar. We're seeking the court to enjoin the state from funding primary elections where unaffiliated voters are excluded from voting in the primary. So then, similar to Pennsylvania or what Matt just mentioned, it would be up to the Board of Elections to decide how they're going to implement going forward. If, let's say, the parties decide that they're going to open it up to unaffiliated voters, and the Board of Election would put out rules, regulations that essentially state that if you're a member of a party, you still vote in your party primary. If you're unaffiliated, you can vote in a party primary. That would be A being one.
Got it. And then the legislature would have to come up with a way to encode that. They'd have to write new rules based on that court decision, right?
I don't think they'd have to write new rules. It would be done through regulation, because right now they say the parties can decide who can vote in their primaries. I want to say it was maybe 20 years ago, the Republican Party did open their primaries up to unaffiliated voters. They did it for one cycle, and it was largely they went back. It was a very close decision of the state party in terms of the voting of the state party central committee. This was before the internet. The party didn't have any money to really explain and get out there and market this. And so it ended after one cycle.
Got it. Yeah, Michael, I remember I spoke to Michael Steele about that. He was involved in making that happen. All right, let me throw a somewhat philosophical question out there. So these are voting rights cases, and the way all of you are talking about them as voting rights cases and voting rights issues, the rights of American citizens who do not wish to join a political party to fully participate. Some of our opponents say, well, wait a minute. Race, sex, these are legitimate voting rights issues. Independent, it's more of a soft, mushy identity. It's not as real as those more biological indicators. And it doesn't rise to the same level of discrimination. It's not a fundamental category worthy of protection. So what do you say to that? And also, let me throw a curveball. What do you say about the fact that a growing number of independent voters are actually people of color? The floor is open.
Okay, that's an interesting issue, because one of the arguments against me by the 11th Circuit was that the white primary cases are something special, and that the injury, they acknowledged I had an injury because that's how I had the right to sue. But they basically said my injury wasn't severe enough. And at one point, they compared it to the white primary cases. And my response on a motion for rehearing is that doesn't mean that every case has to meet the high level of the white primary case of racial discrimination, because the court itself has said minor damage might even lead to a civil rights action. My point is this, my bottom line is this, it's absolutely true. Racial discrimination is barred clearly by the 14th, 15th Amendments. But that's not the only part of our Constitution. We have a First Amendment. And when I talk to European lawyers, one of the things they note is when they talk about civil rights, they mean the rights of a citizen, all the rights of a citizen. And often, I think we're focused just on one aspect of civil rights, and that's racial discrimination. Obviously, that's extremely important, but that certainly should not detract from the importance of our First Amendment rights.
Thank you.
In our case, we go back to the state constitution guaranteeing the right to vote of all citizens. So, and our constitution, they could argue, well, was written before there was such a thing as primaries and before the state legislature in Maryland created the primaries back at the turn of the last century. But that doesn't change anything. They did not amend the Constitution or amend our Declaration of Rights to say, but for the primaries. And so we similar to what Michael was talking about, you don't have to have such a severe injury to violate a constitutional provision. And so that's what we point to. And you're right that there's a large number of people of color who've made a decision that they don't want to be affiliated with either party for various reasons. And some that are here is because they feel one party doesn't necessarily represent their interests and another party claims to represent their interests and has disappointed them consistently. So they have decided that they're going to be either independent or unaffiliated in the case of Maryland.
Yeah, if I may jump in, I have a case that I came across thanks to the librarian at my university. In 1944, the Supreme Court decided that you could no longer discriminate against African Americans based on race. 2 years later, a supervisor of elections in Florida sends up a question to the Attorney General of Florida. We have 316 African Americans who will not state their party. Can they vote in the primary? The answer is no, they can't.
Wow.
When I saw that, what that highlighted to me is this, the irony, that in each case they were excluded. In the first case, because of their racial identity. In the second case, because of their simple rights as a citizen, regardless of racial identity. So it seems to me that there is this coalition of rights that we're not opposed to, that they're not opposed to each other, that in fact they reinforce each other.
I just want to, I agree with everything that was said. And I think God bless the person that has the precision of judgment to declare what is a legitimate voting rights issue from an illegitimate voting rights. That's far above my, poor capacities of judgment. But at some level, it also misses the entire point, right? Because the reason we have the primary systems we do is because the political parties could not be trusted to run their own primaries, right? The state had to step in and say, now that you can't be trusted to be kind of the watchman on the walls of the democracy, right? That we're gonna set rules and regulations that are enforceable in order to protect the process, right? That's why we're in this spot in the first place. And as soon as the state steps in and says, we are going to take this over, the state is bound by all the constitutional protections that apply, right? And they're bound by protections.
That's a great point.
You can't be excluded based on who you are, right? And they're also bound by the restrictions that say you can't be discriminated against based on what you think, right? I mean, in Pennsylvania's case, the whole reason we have the Free Negro Election Clause is because of what you think, because there's a long history in the 1780s and 1790s of discriminating against individuals who had a more kind of transparent democratic bent called the Anti-Propriety Party. And that was the reason we had this concern about voter power, that the state would pick certain voters and say, I'd like to hear from you twice, and you just once, right? I'm not sure that you should have all those chances to register your opinion. And so in my mind, that's the focus, right? Is the state took it over and the state has to play by its own rules.
Right.
Thank you. Jeremy, question for you. And Chad, please chime in here as well. You and I have talked a lot about the importance of litigation as part of movement building, not just what the case is, whether they win or lose, but building the overall movement. Talk about that. How do you see that?
One of the biggest challenges I saw actually when I first came to open primaries 10 years ago, and seen work being done on ballot initiatives and work being just starting to be even conceived of being done in legislatures, and there was nobody going to court. And if you look at every successful change movement in American history, litigation has been a key component. And if you look at any major law that has been passed in this country over the years that has granted rights to any category of voter, oftentimes it has its beginnings in a case. And I think there's a number of reasons for that. I think that litigation by design focuses on the problem,
right?
Not on the solutions. Solutions can be debated, but problems are very clear and they're moral. And when you bring a case, you're bringing it on behalf of specific individuals who've been aggrieved as a result of being denied a right. That is something that many Americans can really identify with. And as a result, it provides a much bigger platform and forum for discussion, for debate, for public education, which is why if you look at the cases that we're talking about on this call today, there has been more media coverage collectively of these cases than every other reform effort this year. And that's because people really want to see what happens in court and how that works in court. And the truth is that if you look more broadly, there's only a handful of states that have a ballot initiative process, right? And that's getting whittled away. Many legislatures are becoming so one-sided that it's going to be increasingly hard to pass laws in this area. So what do we have left? The courts.
Yeah, not to mention Congress. Congress can't do anything, right?
So that's why I think, we've been spending a lot of time in the last year really bringing attorneys together, developing ideas, working to support each other, because this litigation, I truly believe, is going to be the future of the primary reform movement.
Great. One last question, and then I want to open it up. We have a long queue here, and let's be brief. Where are the big voting rights legal shops, the Brennan Center, the Campaign Legal Center, like where are these folks when it comes to these questions of the voting rights of independents?
Right.
You have thoughts, Michael?
If you want me
I don't know. I haven't been able to find them. Believe me, when I first started, I thought, do I really want to represent myself? Because the adage is a lawyer who represents himself as a fool for a client.
Right.
But I thought, it probably will warp my perspective. So I went to all the traditional groups, and I'm not going to mention their names, but you know who they are. These are groups that are very avid in defending voting rights against racial discrimination. God bless them. But I didn't feel that I got a hearing at all. It wasn't in their bailiwick, okay? It wasn't until I found Open Primaries, the Independent Voter Project, and by that point I was on appeal, that I finally found some people on the same wavelength as I was. But yeah, that was a revelation to me, that not every voting rights group is necessarily concerned with the closed primaries. In fact, we had a situation in Florida where Jeremy knows, where we had a proposal to amend the Florida Constitution to allow for the top two open primary. It obtained 57% of the vote, but we needed 60%. And the League of Women Voters, which had initially supported it, at the last minute reversed itself. Now, I don't know all the politics of what went on, but all I thought is, this was a crucial battle. And I kind of thought that, maybe the groups that are supporting voting rights would have helped get it over the top, but they didn't.
Yeah.
Michael's being polite. I've been known
no one ever said that before.
Not to always be as polite. So, we know who these groups are. I used to work for one. I used to work for the ACLU. That was my first job out of law school. Brennan Center, Campaign Legal Center. These are good groups. They do important work. And, I've had conversations with all of them. And I think part of the issue is that they're still fighting many of the fights that they've been fighting since the passage of the Voting Rights Act. And the truth is that those are real fights. We know the Supreme Court is on the verge of rolling back some of those rights right now. So that's real. But those are very limited frameworks, and they haven't been able to expand their thinking beyond that. I think that's a real problem, and I think they're behind the times. My hope is that by continuing to raise awareness of these cases, and quite frankly, by the fact that they're not successfully connecting with where the real serious and now most expansive voting rights issues are in this country that Americans care about, that a new conversation is possible.
I'm going to take the more cynical viewpoint here.
Okay.
I think most of these groups are afraid of their funders, and their funders on either side of the aisle are wedded to the political parties.
Right.
What we hear from legislators here, it's more of, well, we have our voters. We already have our voters. Why do we need more voters? Why do I need to appeal to more voters? That means I have to raise more money to appeal to more voters. Or we even had one elected official said, why would I want people to vote who are not going to vote for me? So that's, at least that's my view, why some of the traditional groups are not turning in that direction. I think some of their funders might not like that approach.
Okay, good point.
All right, let's open it up. We have, I want to apologize in advance. I already know we're not going to get to every question. We have some fantastic questions here. I want to start with Brian Shank, who has a question about sore loser laws. Go ahead, Brian.
All right, thank you. I really do believe firmly in fixing the broken primaries. I think they're terribly broken, and it's kind of an urgent situation to fix them. But I've always believed with this issue that we've improperly combined public functions with private ones. So I think the winnowing of the field process and the nomination process have been combined. It creates horrible problems. And so I'd like to specifically target the sore loser laws, because I think that's kind of where the problem is. So so rather than having party non-members interfere in what should be private nomination proceedings, so I think it'd be better to just abolish the sore loser laws. And once you do that, parties are no longer able to dictate election outcomes anymore. And once they can't do that, they can be as exclusionary as they want to be without any real harm to voters or to election integrity. So I guess my general sense is we need to separate the public from the private aspects of these. And I think in a sense, by putting too much emphasis on getting non-members to participate in these primaries, we may be to some degree barking up the wrong tree. I think maybe emphasizing the sore loser laws, at least seems to me, to be the more correct emphasis.
Thoughts on that, anybody?
Well, I mean, on the sore loser law itself, you haven't eliminated the fundamentally unequal component of it. Okay, so you keep sore loser, you get rid of sore loser laws. I'm in New Jersey. I'm an independent voter. I'm one of the 50% of the electorate that can't participate in the first round of the election. How does that improve my influence or make my influence equal in that process, just because the candidate who came in second place in the Republican primary can now run again in the general election, right? I think sore loser laws, I don't agree with them, right? But I think they're two different issues. And a lot of times we do get wrapped up in different issues. I think the most important thing you brought up, though, is separating the public and the private purposes. And that when we're looking at this history of litigation, right, what's important for us to consider is that what Paxton is saying right now in Texas is exactly the same thing that the Democratic Party argued in California, which sets the frameworks for the legal constructs of our traditional primary systems. In California Democratic Party v. Jones, it was the California Democratic Party, ironically argued by the Republican Party's attorney, who said, this is a private associational activity, and you cannot allow voters to jump in and participate in our open primary, right? And that's what invalidated the old open primary. So why did we go to a top two in California? Well, that was because Washington had adopted it, and Scalia in the concurring opinion of Democratic Party v. Jones said, well, if you want to have an election serve everybody, it should serve a public purpose, just have a nonpartisan primary. Right. To Brian's point, you can maintain the private aspect and have a Republican primary and a Democratic primary, and also have a public component where everybody else could participate. There's 1,000 ways to run an election.
Right.
The issue is when the state, not the parties, when the state constructs a process that says these voters get to participate and these voters just have to wait, right?
Got it. Thanks, Chad. I want to go to Georgia and Tracy Moore, who has a question, a very interesting question I've never heard before. I'm not even going to try to summarize it. Go ahead, Tracy.
Boy, now you put me on the spot on how.
No, I didn't mean to. But
so Georgia has, I don't even know the right terminology, semi-open. Basically, you don't have to register ahead of time. You don't even have to declare that you're part of a party. However, when you get to the primary, you are limited to either the Democratic slate or the Republican slate. So my question is for the legal scholars, what is preventing us from challenging that aspect, even in all your other states? So I know that's not necessarily what Maryland has, but if it's illegal to block somebody from voting, then isn't it illegal to block them from voting for half the candidates? And I don't know how best to word it, but what is the argument around?
Because about 20 states have the system in Georgia where there's no party registration, and you just ask for a ballot.
Go, right? That's going to be the default. Even if you win, this is going to be the easy way out for people and still have their cake and eat it too, and is not helpful. We want completely.
So what you're saying in Georgia, you don't register by party, but you can only vote for one in the party primaries. And you're saying you want to vote for what, the Green Party candidate or the Green
I
Party?
may want the Republican governor, but the Democratic Secretary of State.
Oh, I see what you're saying. Okay.
Yeah, so different race.
Yeah. You'd want to be able to pull. I guess the challenge that you're going to run into, though, is the situation where, I mean, if they put it on a single ballot, then you could probably get past that. But if they give you two ballots, you could have people who vote for both the Republican governor and the Democratic governor. So they'd have to have their system where it's all on one ballot, that it only clicks one person, so that you do have that one person, one vote. That's
Which is
not our
what California
situation
has,
here.
right?
That's,
Well, the
yeah, but
California-
they do the top. Yeah, they go to the top two, I believe. Yeah.
Yeah, but the California that was struck down, that's how it functioned. It was called an open blanket system where I could vote for the Democrat for Senate and I could vote for the Republican for governor, right? And that was the particular open primary system that the Supreme Court struck down in Democratic Party v. Jones.
And I mean, from my perspective, there's a difference between exclusion and limitation. So our lawsuit focuses on the fact that a class of voters have been excluded, and we think that raises serious constitutional questions under Pennsylvania's constitution. I think when you get into limitations on how that process works, I think undoubtedly there's legislative space here for individual legislatures to decide how they think this makes sense. There are arguments about the administration of the election and ensuring there's not voter fraud, ensuring there's not party raiding. I mean, I think the point about California v. Jones is a very good one, that mean that there can be different flavors of primary processes that are all constitutional, even though they may limit the entire breadth of the choice, right? And so I do think there's that space for legislative choice. In Pennsylvania, we frankly would love what Georgia has, right? I mean, at some level, right, our issue is that you're out of the ball game entirely, and we would love it that at least you can play on a team, right? That would get us some way.
And in the big picture, we still know primary election turnout is quite small. So even as more people become independent and we open that up, is that going to change the needle? It's the right thing to do, but is it going to change the needle?
Well, that's just to get on my soapbox for a minute, Tracy, that is a massive cultural political question as less of a legal question, because right now, even in the states in which independents have been given full voting rights, you see low overall turnout in the primaries and low turnout among independents. And I think part of that is that the American people, all of us, we've been educated that primaries are where the partisans vote. November is where the regular people vote. And we have to change that culture. But that's not a legal issue as I see it. All right, let's go to Bart Farrar in Philly. Go ahead, Bart.
Oh, hi. Sorry, my camera's not working right now.
No worries.
I just, we've, Let Us Vote has the petition for our lawmakers. But is there any individual action we can take? Any calling of any, attorneys general, Congress people? And if so, is there any kind of script that we could use along those lines to kind of push this issue?
Matt, anything people can do in Pennsylvania that you would find particularly helpful?
I mean, with respect to the lawsuit, not particularly, right? That's a lawsuit. It's going to go in its own track and its own direction. The law is what the law is, right? And we'll litigate that. Just speaking for myself, I mean, I think the easiest way in Pennsylvania specific comment, to open up our primary process is for the political parties themselves to say we want to open it up, right? There's good case law that says the state can't stop that if the parties want to. So what I encourage everybody to do, I would encourage Bart to do, right? Reach out to your local Democratic Party, reach out to your local Republican Party and say, hey, you want me to vote for you in the general election? Let me vote for you in the primary, right? I mean, at the end of the day, we always hear that independent voters, Pennsylvania, I hear this every day, right? Independent voters are critical. They're going to determine the Keystone State. Keystone State could determine the presidency, blah, 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 blah. If they're so important, then why are the parties taking a position that they shouldn't be participating at that first election in the Commonwealth. So I would just tell people to vote, say, hey, kind of let me in, right?
Yeah, I appreciate that. And I think a good talking point is using that latest Gallup poll that was just shared with us.
Right.
You know, where 47%
47,
of Americans
right.
now identify. I mean, we're the largest voting bloc. So I think we need to really rally behind that as much as we can. Thanks, appreciate it.
You know, I would just add one thing. It's one of the reasons why it's so important to raise awareness about these cases in the states where they're occurring is because these cases can have an effect on all kinds of activities beyond just the courts. I'll give you one example. Because of the work that Boyd is doing in Maryland, we got a call a couple of weeks ago from a delegate from in the Maryland legislature who said, I love this case. This is really important. I really care passionately about this issue. I'd love to work with you to develop legislation to get introduced into the Maryland legislature. That's exactly the type of activity that we hope these cases engender beyond just winning in the courtroom, but that they build a conversation. So I encourage everybody who lives in these states to use them in that way.
Can I add, Jeremy, and particularly talking about, she is a member of the Democratic Party, which has an overwhelming majority in our state legislature. So the fact that you have, you know, it's okay for the Republicans from time to time raise those kind of issues, and there have been some legislation trying to do that and sponsors, but that gets pushed to the side. But where you have a Democratic, member coming in and saying that they really want to push this forward, I think it gets a lot more attention.
All right, I want to go to Lee Bennett in Illinois, who has a question about the current system in Illinois. Go ahead, Lee, and I'm very interested in this. I live in Chicago, and I'm eager for your question. Go ahead.
Yeah, like the discussion with Georgia, we can pick a party and vote either way, but it seems one of the issues there, whether you have to register or your action of which thing you take, is a matter of public record. And so it's like, I feel like my vote's not private. I shouldn't need to publicly list that I'm a Democrat or a Republican. Can't this kind of system be partisan system? The separate the private from the public has been raised, but yeah, is there a privacy challenge that could be if we can deprive the system of who's on blue team, who's on red team, things like gerrymandering are weakened?
Thoughts on that, anyone?
Well, one of the arguments raised in my case was why we need the closed primary is that the parties have to know who their voters are. And my argument was they already know because it's a public record. You don't need a closed primary. It's a public record. Even in Illinois, the parties, even though it's not recorded, is it a public record? The precinct captain or the party official would be there checking off people at the election day, seeing what ballot they picked up. And that's how they knew who their voters were. One of the problems has been raised with the Illinois system and others like it, call it semi-open or open, is that the parties are beginning to say that violates our rights because people who say they're a Democrat for a day or a Republican for a day, they just come and pick up a ballot. They're not really party members. That it really has not reached the court. There have been a few members of the court who have wondered about that. And maybe that's one reason why the Supreme Court is holding off a bit, because the closed primaries might unravel a number of other cases. Because there's a question. What does it mean to be a party member, by the way? What does it mean? When the Democrats and the Republicans, the Democrats can't even agree on who a real Democrat is.
Right.
And then we have rhinos in the Republican Party. So it doesn't even have any meaning anymore.
Right. Go ahead, Matt.
I want to pick on that point because I think it's a really important one. And I do think there are two analytically distinct concepts, right? So there is the public act, which is done for the purposes of allowing the state to administer the party, which is say I choose to vote in the Republican or Democratic Party, or I choose to enroll for the public purpose, for the state purpose, as a Democrat or Republican. But that does not ipso facto make you a member of the Democratic Party, right? I mean, there are rules, right? Particularly if you're an elected member of the Democratic Party, right? You could violate one of those rules. You could be a defrocked member of the Democratic Party, right? But I could still participate in the Democratic primary. I could still register as a Democrat. So I think that's a good point because they are analytically distinct concepts. And I think that's important because I do question the veracity of the First Amendment party association affiliation claim because the parties do nothing to gatekeep, right? Like back in the day in the 1880s and 1890s in Pennsylvania, there was an oath, right? You had to swear that you voted for Democrats, right? All through your time. And so you can't kind of have it both ways, right? Either the system is open, in which case everybody should vote, or you want to shut the system down, in which case you need to maintain the private-public distinction because distinctions that a private entity could make are not those that the public state can make. And I think it's right that we in our litigation trying to push on that point to say that at the end of the day, we're talking about a public thing, and that public thing must be non-discriminatory. If you want to do a private thing, that's separate. And oh, by the way, you lost your private thing because you were hopelessly corrupt. So if you fix that, maybe then, we're all in a better spot.
Right. That's an excellent point, that the parties are trying to have it both ways.
Yep.
They want all the privileges of being a private party, but they want somebody else to pay for it.
Yeah.
And they want the right to exclude people.
Yeah.
You're right. That's the heart of the issue.
I wanted to go to Jen DeSaro, who has a question of parties' location in the state election code. Go ahead, Jen.
Oh, sorry.
Hi, Jen.
Yeah, sorry. I was curious about whether or not anyone has tried to just remove the partisanness that is in the state statute. It came up in a discussion in one of our corporations committee meetings in Wyoming. And so I'm just curious how that would play. If it was put in there because of the need to take over the public act of the election, and what would happen if we removed it? Not that, I mean, this is pie in the sky. I'm talking Wyoming, but just curious.
Well, Jen, if you removed partisanship from state election codes, there wouldn't be much left, because the truth is I've done studies with Arizona State University where we've gone through all 50 state election codes piece by piece. And what you'll find is partisanship is baked into every aspect of state election codes, which is why we're now talking about the fact that independents are barred legally from voting in primaries in so many jurisdictions. But the truth is that the second class status of independence goes far beyond that in state election codes. In many states, they're barred from being poll workers, poll watchers, serving as election judges, serving on boards of elections. There are aspects of interaction between independent voters and a more partisan focused election code throughout. And that's because it's not because someone sat down one day and wrote it all down. These election codes have evolved over time by state legislatures, which are made up of Democrats and Republicans, and they write these codes in a manner that fits them. And most of them were written long before the idea of an independent voter or the magnitude of independent voters was a reality.
Right.
Yeah, I mean, we have a situation. I mean, our judicial races are supposed to be nonpartisan for circuit court. They're basically retention elections. The governor nominates circuit court judges. That's I would say the entry level trial court. And after a year, they stand for election, and it's a retention election. It's considered nonpartisan, but their names appear on both the Democrat and the Republican ballot. If that person happened to be unaffiliated, they would not be able to vote for themselves. So and there was a case about 20 years ago that has some language that goes against our case right now that upholds that. And it was sharply criticized in a concurring opinion, because the concurring opinion said, well, they did not meet the requirements of the statute. You didn't even need to get to this particular issue, which runs afoul of our case. And they raised the point that if an unaffiliated judge, let's say, brought up the constitutional claim, it should throw this whole thing out. And that case, but that situation has been criticized. All the circuit judges hate that decision, and they hate the fact that they have to sit for retention elections also. But it's strange. It was once described as a imperfect hybrid of a situation in terms of these judicial elections.
All right, we have only time for one more question. I apologize to everyone whose question I did not get to. There's literally 8 great questions that I wish we had another hour for, but I want to go to Jim Resser to close us off. Go ahead, Jim. You there, Jim? All right, maybe Jim has left. We're going to go to Lenny Gluckenheimer in Florida. Question about the Democratic Party. Go ahead, Lenny.
I'm a Democrat in Florida, and there's been discussion about whether the Florida Democratic Party should open its primary, and it's against the state law. And if they're challenged, they'll have to file a lawsuit. What would the resources be available to help the Florida Democrats to have this case? And also, I'd like to have some way of getting contact with Michael.
Oh, sure.
We'll hook you up. We'll hook you up.
Sure. Be glad to.
Any thoughts on that?
Yes, actually, while I was preparing the appeal, I don't know exactly what stage, I got an email from Nikki Fried inquiring about my case because she was interested in, opening up potentially the Democratic primary. And one thing led to another, and I came into contact with Mitchell Berger, who I understand it represents, I think, the Democratic Party, or at least in Democratic Party cases. And I supplied him with copies of my briefs, and he seemed interested. So I thought, that would be wonderful, because I agree. I think it was with Matthew that the best case would be for a political party to go to court in Florida and say, we want the right to open up our primary. There's a case that was decided by the Supreme Court, pretty much open and shut, that said if the Republican Party of Connecticut wants to open up its primary, it has a right to do so under the First Amendment, no matter what the law of Connecticut is. So I was trying to encourage them to go to court, because it would save me a lot of trouble and it would get to where we wanted to go. But that has turned cold. I haven't heard anything. I suspect, I don't know, Jeremy might know, but I know Nikki Fried's no longer a candidate for governor. And so that impetus may have been lost. And I know there's division within the party what to do. That's all I know about it.
All right, thanks. Thank you. We'll make sure, Lenny, you and Michael get connected. And also, it's good to know that David Jolly, who is a leading Democrat for governor, running, he used to be a Republican, then an independent, now he's running as a Democrat, that he's a very strong supporter of open primaries. So we might be able to leverage some of that, his participation in the gubernatorial race. We have to stop. I want to encourage everyone to tune in to CNN tomorrow morning on the Smirkana Show to watch our fearless attorney, Michael Palelli, argue our case. He also did a podcast with Mr. Smirkanish today, which is great and goes into a lot more detail about the federal case. Before we end, Jeremy, maybe you could say a few words about the growth of the open primaries litigation platform and ways that people can help with that.
Yeah, so, as we've been discussing today, we have the wind at our backs. There's a lot going on. We've got all kinds of activity going on around the country at the state and the federal level. And it's only going to grow bigger. We need more resources, and we need more attorneys who want to get involved and help us look for opportunities at the state and federal level to begin to break more ground and start to add collectively to this effort. So I'm putting my my email in the chat. If you're an attorney, or if you know an attorney who wants to get involved, if you or somebody you know has resources that they want to help bring to this effort, please do. We're working to bring cases directly. In the case of Maryland, we're working with partners like Independent Voter Project and CHAD, and we're working to support attorneys around the country like Michael and Matt, who are doing this important work, and we need all the help we can get.
Great. Thank you, Jeremy. Jeremy's email will also be in the follow-up email that everyone gets with a recording of this video in just a few days. Thank you, everyone, for participating. Thank you, attorneys, for taking time out of your busy day to share this exciting and developmental news. Have a great weekend, everyone. We'll talk to you soon.
Thank you.